You're going to be under arrest.
For what?
For not listening to me.
I think the emergency is the video, somebody's videotaping.
And the shirt says, I believe, balls deep. He says his name is Captain Awesome.
Hey guys, today I wanted to come to you guys with a different kind of video, more informational. Today we're going to be looking over Glik vs. Cunniffe, United States Court of Appeals, First Circuit, August of 2011. Now we all know that this stands for a right to record case out of the First Circuit, right? It's one of the more famous ones, one of the more earlier ones, and so people know it by name, and they cite it. But we're going to really get into it and see what some of the logic is behind some of these cases, right? Now, some cases in the right to record area, they stand for what I like to say is the right for everybody to be pressed, right? Then some right to record cases, the logic spoke of in the dicta indicates, you know, the right of access, right? So it's important as auditors that we read these cases, we understand the logic behind the rulings, and you know, there's also other rulings, you know, cases cited that you'll want to explore as well that branch off, right, to see the logic behind those rulings as well, to get a better picture overall on your right to record. Now, I'm not going to read through the whole case. I'm going to pause and skip ahead to certain parts that I want to talk about, but definitely take the time out and look this case over. Alright, so give me a second, we'll be right there. Alright, so the facts on the case are this. Mr. Glik was arrested for using a cell phone digital video camera to film several police officers arresting a young man on the Boston Common. Now, they charged him with the wiretap statute and a couple other state law offenses. They were all judged baseless and were dismissed, right? So we know the facts of the case. Gentleman's out in a public forum. He's using his cell phone to capture videotapes of police, right? That's the facts of this case. But again, I want to get into some of the cases that they cite and some of the logic behind the meaning. So let's continue on. I want to stop here, guys, and discuss qualified immunity, right? Because we all face it when we go into civil court, and in some districts, there is no right to record, right? I believe in the 4th district, in the 2nd district, in the maybe even the 6th. I'm not sure about the 6th, 8th district. I know the 10th district just won a case last year. Aziri won his case there, establishing the right to record. But we don't need precedent, right? And here's a quote directly to that point. It says, an affirmative finding on these inquiries does not require a case directly on point, but existing precedent must have placed the constitutional question beyond debate. Ashcroft v. Al-Kid. Alright, and what that's saying is that if the question of if the right is firmly established is beyond debate, then you don't need a case precedent saying you have this right. So when we're discussing the right to free press, and when you're involved in cases like this, it's important that you bring up, because a lot of people have forgotten, right? But it's important that you bring up the fact that the right to free press is the right to watch over our public officials, okay, and bring that information to the citizens so they can make informed opinions on how their leadership is operating, and if you need new leadership, or it's to inform the citizens so they can make a better choice on who's running the show. This has always been the right to free press's constitutional importance, right? I'm going to mention two things here. You might want to write them down, look them up on Google. These will help immensely with showing what the constitutional importance of the right to free press is. And one is the 1774 letter to the inhabitants of Quebec. Okay, and in that it states that the right to free press is the right to shame our public officials into doing what's noble. And the second quote is going to be from Thomas Cooley's General Principles of Constitutional Law. In my copy of the book, it's on 301, 302, but it's in the part of the book that discusses civil rights under free speech and free press. And in that, Justice Cooley says that the chief importance, constitutional importance of the right to free press is to record the actions of our government and bring it to the bar of the public opinion, so again that citizens can be informed on how they make decisions. We don't need a case law that says, oh, you have the right to record your public officials. Just like you don't need a case law that says you have the right to bear arms, right? Because that's what the whole right is about. There is no better established right than, the First Amendment, the right to free press. It's well established. Every citizen should understand the right to free press and what that is. I don't need case law saying, hey, you have the right to record the mayor. Hey, you have the right to record the police chief. That's well beyond debate. Hundreds of years beyond debate, right? So I wanted to bring that up because I know qualified immunity is where a lot of people stutter, but we definitely have a well-established right in the right to free press and recording our officials. Now we can see here what I was just talking about. Okay, so in part one of their discussion on immunity from Glik's First Amendment claim, in the first paragraph here it says the First Amendment issue here is, as the parties frame it, fairly narrow. Is there a constitutionally protected right to videotape police carrying out their duties in public? This is the important part. Basic First Amendment principles. Okay? What are basic First Amendment principles with the right to free press? They are the right to record public employees, government employees, right? That's a basic First Amendment principle, right? Along with case law from this and other circuits, answer that question ambiguously in the affirmative. All right? Basic First Amendment principles. And here's another important part here, folks, especially for those of us that go into buildings. It says, as the Supreme Court has observed, the First Amendment goes beyond protection of the press and the self-expression of individuals to prohibit government from limiting the stock of information from which members of the public may draw. So First National Bank versus Bellotti. It also says here, it is well established that the Constitution protects the right to receive information and ideals. An important corollary to the interest in protecting the stock of public information is that there is an undoubted right to gather news from any source by means within the law. Okay? That goes back to the fact that wherever the public may gather information, the press can also gather information. They go on to say the filming of government officials engaged in their duties in a public place, including police officers performing their responsibilities, fits comfortably within these principles. Okay, that's the basic First Amendment principles of the right to free press equals the right to watch your government, record your government, report on your government. Gathering information about government officials in a form that can readily be disseminated to others serves a cardinal First Amendment interest in protecting and promoting the free discussion of government affairs. That's Mills versus Alabama. Moreover, as the court has noted, freedom of expression has particular significance with respect to government because it is here that the state has a special incentive to repress opposition and often wields a more effective power of suppression. Now, what does that mean? It means that the court has noted that when it comes to the press, citizen journalists, whoever, reporting on government, they have a special incentive to repress things that go against what they want the masses to know and understand. And it also wields a more effective power of suppression, being that it, has this gang of people with guns that they can come and they can remove you, and they can suppress your right through violence, right? So this is the court stating that there's a significance with what we do. It says this is particularly true of law enforcement officials, obviously, who are granted substantial discretion that may be misused to deprive individuals of their liberties. That's Gentile versus State Bar, Nevada. It's a SCOTUS case. It says observing that the public has an interest in the responsible exercise of the discretion granted police and prosecutors. It goes on to say that ensuring the public's right to gather information about their officials not only aids in the uncovering of abuses, recognizing a core First Amendment interest in the dissemination of information relating to alleged governmental misconduct, but also may have a salutary effect on the functioning of government more generally. See Press Entertainment Court versus Superior Court, another SCOTUS case, 478 U.S. 1, noting that many governmental processes operate best under public scrutiny. Okay, this is the case law that the trolls don't understand, that the trolls have never seen, that the trolls have never bothered to, look up. And again, this is a Supreme Court case noting that many governmental processes operate best under public scrutiny. So City Hall might operate best under public scrutiny. The police department might operate best and does operate best under public scrutiny. It goes on to say, in line with these principles, again, these are basic First Amendment principles: watching over the government, reporting their activities to other citizens. These are basic First Amendment principles. There needs no case law to say that you have the right to video record your public officials, right? It's basic First Amendment right principles, right? They've been here all along. They're well established. It says, we have previously recognized that the videotaping of public officials is an exercise of First Amendment liberties. In Iacobucci versus Bolter, which is another case that you folks definitely need to read and understand. It says a local journalist brought a 1983 claim arising out of his arrest in the course of filming officials in the hallway outside of a public meeting of a historic district commission. Now, what's interesting about Iacobucci is that it kind of blows apart the trolls' whole public forum doctrine thing, right? Because Iacobucci was in a hallway, okay, in this building, definitely wasn't in the public meeting anymore, right? He had stepped out from the public meeting, which he was allowed to record in, obviously, out into the hallway, and he was recording out into the hallway. Now, there was no forum analysis done in Iacobucci, and that, again, goes along with the principle that wherever the public's allowed, the press is allowed, right? And in Price v. Garland, which was that case decided by the D.C. Court of Appeals last year, they specifically state that a blanket ban on filming, recording public officials is unreasonable no matter the nature of the public building. Meaning, no matter what, if it's a limited, non-limited, non-public forum, designated public forum, whatever the forum may be, it's irrelevant to the fact that you can't have a blanket ban on recording public officials. Doesn't matter where they're at. As long as you're there legally, you're allowed to record public officials. That's just the bottom line, right? This is something that they're going to have to get used to, right? This is all included in those basic First Amendment principles, right? And it said the commissioners had objected to the plaintiff's filming. And here's a quote from that case that's pretty important, and it says, we explicitly noted in rejecting the officer's appeal from a denial of qualified immunity that because the plaintiff's journalistic activities were peaceful, not performed in derogation of any law, and done in the exercise of his First Amendment rights, the officer lacked the authority to stop them. Right? Because the officer doesn't have unlimited authority. And because this gentleman was peaceful, he wasn't breaking any law, and he was exercising his First Amendment right in this building, in this non-limited forum, that the officer lacked the authority to stop them. And, if you read the Sheets versus Punta Gorda case, because a lot of people, a lot of trolls especially, like to say that case stands for the fact that you can't record in buildings, but it absolutely does not state that. In fact, what the judge says is that Mr. Sheets was allowed to record in the public building and no one could stop him, right? No one could stop him. No employee could stop him, she said. And that's simply because if he's in a public area where the public can be, then he can, record. Now, what the court did say in that case was that he wasn't allowed to record people without their consent, which, as we all know, is hogwash. And that court case is definitely set to be challenged. So, all right, let's go on. Now, here we get to the part, guys, where it goes into the fact that the First Amendment doesn't just apply, the right to free press doesn't just apply to news media, right? So it says, it is of no significance that the present case, unlike Iacobucci and many of those cited above, involves a private individual and not a reporter gathering information about public officials. The First Amendment right to gather news is, as the court has often noted, not one that inures solely to the benefit of the news media. Rather, the public's right of access to information is coextensive with that of the press. And that's from another Supreme Court case, Hutchins, which is cited there at 438 U.S. at 16,98. Or, 16. Stuart J. concurring, noting that the Constitution assures the public and the press equal access once government has opened its doors. Right? Now, in these cases, you'll notice one thing, and you ask a lawyer what the legal theory is today, and that is just what Justice Stewart said there. Public and press, equal right of access, right? It doesn't say equal right of access unless it's a limited forum, unless it's a non-public forum, right? You can't read more into case law just like you can't read more into a statute, right? So what's not included is excluded. That's a famous maxim of construction of law, is that what's not included is excluded. So it doesn't say that the public and press have equal access once government opens its doors unless it's a limited public forum, or unless it's a non-public forum or a traditional public forum. It's equal access. So again, if they want to stop independent journalists from coming into buildings, they would have to make the building inaccessible to any public, right? As long as it's accessible to public, it's accessible to press, right? Again, this is something that's been on the books here forever now, right? So it's nothing new. And here in Brandsburg, they quote, it says the First Amendment does not guarantee the press a constitutional right of special access to information not available to the public generally. And again, that stands for the same thing. The press has no special right to go anywhere that's not available to the public, right? There is no special access. We have the exact same right of access. And it says, indeed, there are several cases involving private individuals among the decisions from other courts recognizing the First Amendment right to film. It goes in with Smith, Robinson v. Fetterman, holding that arrest of individual filming police activities from private property violated First Amendment. Cirillo v. Town of Johnston School District, holding that teacher had a right under the First Amendment to videotape potentially hazardous working conditions at school, which were a matter of public concern. Oh my God, but the teacher videotaped in a limited public forum. Oh no, right? It says, moreover, changes in technology and society have made the lines between private citizen and journalist exceedingly difficult to draw. The proliferation of electronic devices with video recording capability means that many of our images of current events come from bystanders with a ready cell phone or digital camera rather than a traditional film crew. And news stories are now just as likely to be broken by a blogger at her computer as a reporter at a major newspaper. Such developments make clear why the news-gathering protections of the First Amendment cannot turn on professional credentials or status. Right? So the Glik case is one that I like to go to when I'm, answering questions about, who is the press, who has the right to gather news. All right, so excellent case here. Let's continue. Going down here to 85, we find more evidence of the not needing the case on point. And it says this terseness implicitly speaks to the fundamental and virtually self-evident nature of the First Amendment's protections in this area, noting that some constitutional violations are self-evident and do not require particularized case law to substantiate them. We thus have no trouble concluding that the state of the law at the time of the alleged violation gave the defendant fair warning that their particular contact was unconstitutional. Okay? Self-evident nature of the First Amendment's protections, right? Again, it's self-evident because it is the right itself, right? Like if you had a right to hold a spoon in your hand, you wouldn't need to then have a case law that says that you have the right to hold a spoon in your hand for that right to be self-evident, right? Because it's already self-evident. That's what the whole right is about, right? Just like I made the case for the right to bear arms, right? You don't need case law saying that you have the right to bear arms, because that's what the whole Second Amendment is about, right? And the same goes with the right to free press here. Alright guys, in summary, though not unqualified, a citizen's right to film government officials, including law enforcement officials, in the discharge of their duties in a public space is a basic, vital, and well-established liberty safeguarded by the First Amendment. Okay? It's a basic, vital, and well-established liberty that we could record public officials. And again, we don't need case law to say that. We don't need this case law to say that we have the right to record public officials. But again, I wanted to show everybody this. I'm going to go ahead and cut it off now. It does go on to discuss Glik's Fourth Amendment claim, which has no bearing on what I've talked about today. It's based under Massachusetts wiretap law, so unless you're in Massachusetts, it really doesn't even apply to you. But in this case, to me, stands for the right that everybody can be a journalist, right? Everybody can be news media and gather news to disseminate it to the public. That's Glik versus Cunniffe. Definitely a good case for any auditor to read, and every auditor should have read it before even picking up a camera and going out there. But so if you haven't, guys, definitely take the time to check this out. Happy Easter to everybody, and I'll see you guys on the next one, okay? We're getting ready to do a public right-of-way video coming up, so be on the lookout.